This topic is an incredibly important area for you guys to focus on, especially getting back to the office and going back to the day-to-day operations. The construction industry right now, in Florida and nationwide, is absolutely booming. In the 5 years that I've been with Naini Construction Law, our practice has grown from 5 to 35 attorneys, just based on volume, just based on the amount of work that our clients have. One problem that we do see repeatedly is accounts receivable issues. Just clients aren't paying, GCs aren't paying subs, things of that nature. And quickly that can spiral out of control if you don't monitor it closely. One primary issue that we've been seeing on a lot of more larger scale projects is obtaining final payment. Whether it's the property owner or the general contractor, the general vibe I'm getting is that those people in those positions feel that they can hold all subs' feet to the fire and say, hey, we're going to hold off final payment for as long as possible to either force you into accepting a lower amount or just delay it to prolong the process, whether it is to prevent them from filing a bond or lien claim or just to try to get them to accept a lower amount. Seeking legal counsel, as much as you want to avoid that typically in your day-to-day business, is imperative to help you protect your rights in those situations. Before we get into the actual collections part and what rights you have, it's important to discuss contracts, because ultimately the statutes, or in whichever state that you work in, it only governs a little bit of what rights you have. In most circumstances, your ability to collect in any scenario is governed by the contract in which you were working. One key thing that I typically have my clients focus on is, especially in the larger scale projects that have 10-plus page contracts, oftentimes they incorporate the prime contract. And a lot of the times, especially when we get it after the fact, when we get it after the project's already been completed, that's something that our clients do not have a copy of. When I say, okay, the venue provision, for example, there's no venue provision, but it does incorporate the prime contract. Can I see a copy of the prime contract? I'd say 90% of the time our clients doesn't have that document. And sometimes, once I get that document, it'll say venue is in Texas when it's Florida project, Florida businesses, and that can be a headache when you want to proceed with a claim. That's something that I typically recommend my clients negotiate on the front end, as opposed to trying to fight the enforceability of it on the back end. But that's just an example of why it's important to read your contracts closely, take a look at things like incorporating the prime contract, also to take a look at notice provisions. If there's a claim provision where you have to provide notice of a dispute within a certain time period, you want to make sure to hit those time periods. Now, I'm not saying if you fail to meet those requirements, you're outright barred from making a claim, but when it comes to filing a claim, that's just another obstacle that you have to overcome. Little things like that is incredibly important, and plans and specifications are often very important as well. Contractors in the roofing industry, they typically have a good understanding as to what their obligations are. When it's a general contractor who has a more broader scale project, it can be a little bit more problematic sometimes, especially if the plans and specifications are coming from the owner. Florida law does provide some avenues for you to get out of it if your work does not strictly comply with the building code, if you built it in accordance with the plans and specifications provided by the owner. But generally speaking, we always harp on reviewing those plans and specifications closely and make sure that there is nothing unusual or nothing that could potentially violate either the Florida Building Code or any local ordinance. Speaking of the contract provisions, there's some things that we typically want you to either look closely at when you get a contract or something to include in your contract. Pay when paid provisions. That is a big obstacle sometimes when you are a subcontractor or beneath that trying to recover payment. Oftentimes we'll send a demand letter out to, if we're a subcontractor representing a roofer, for example, we send a demand letter up to the GC and say, hey, we're done on this project, you've been withholding payment for X amount of days, please pay us by this date or we're going to sue. A lot of times the response we get is, hey, read the contracts, pay when paid, we haven't gotten paid yet by the property owner. So under the contract, you don't have a right to recover against us. So that's one thing to closely look at, to see if your contract has that language. Again, notice provisions. Another issue we pop up aside from pay when paid is change orders or change directives, things like that. Make sure you read that language closely. Sometimes the contract mandates that the change order is in writing. Sometimes it mandates that it's signed by both parties. read that closely, because if you get an email from Joe the GC to make some significant change and you go ahead and do it, yeah, you might have an equitable claim against them, but under the contract, they could potentially point to the contract and say, well, hey, that was just a discussion. We didn't have an official change order. Your contract requires both sides to perform this work in a signed writing. Delay provisions. Sometimes your project is delayed beyond your control. If you don't provide notice in accordance with the contract sometimes, you are still stuck to that project schedule. So in the event that you are held up because the framers are late or something else happened, even weather circumstances, you are oftentimes required to provide written notice to the upstream party, whether it's a GC or the owner, to ask for additional time to perform the work. Disclaimers. If you have control in your contract, especially for roofing contractors, a lot of the general liability policies exclude coverage for mold claims. That's an example of a disclaimer that we would recommend including in your contract. Any damage, any mold damage related to water intrusion during the course of the project would be excluded from any claim for breach of contract. Primarily, we like to include that language because the CGL policy would not cover those damages. I know I'm flying through this, but there's just a lot of little things I want to bring to your attention, so when you do see this down the road, it kind of clicks and say, hey, I've heard someone speak about this before, let me read this a little closely. Consequential damage limitation, for example, if you're drafting your contract, one thing I would like to include in there is limiting either the total amount of damages, including fees, or consequential damages to the dollar amount of the contract. If you're doing a $20,000 contract, you don't want to be on the hook for $100,000 worth of damages. You can oftentimes include that language in the contract and include additional language that says that it's a material term of the contract and that there's valid consideration exchange to make sure that that's enforceable. Dispute resolution provisions. A lot of the contracts may have not only that you provide notice, but once you provide notice, you're obligated to bring the claim to an independent decision maker, whether it be the engineer or the architect. It could require that you mediate the dispute prior to filing suit. It could mandate that you go to arbitration instead of going to circuit court. There's a lot of little things in the dispute resolution procedure that you should follow because ultimately it could prolong the dispute if you do not follow it or potentially even prevent you from bringing a claim. Lastly, I brought up this example before, but venue, choice of law, attorney's fees. Venue is where you're going to be bringing the action. A lot of the times, especially with the big developers, their venue provision is wherever their home office is located. There's a lot of big developers in Texas, a lot of big developers in Georgia. If you're working on a project in South Florida and you're a smaller contractor and you have a venue provision in those states, that's something I may push back on. If you seek legal counsel, oftentimes even the biggest builders out there will compromise on that because they may have local counsel who have been helping them out with the contract in the first place. And the attorney fee provision. I can't harp on this enough. Having a prevailing party provision in a contract is incredibly valuable. Oftentimes I get consultation calls or we have a client call that says, hey, I'm on this project, I'm owed $20,000, they're beating me around, let's go ahead and file suit. I said, well, when was the last day you worked? 6 months ago. Okay, so no lien rights. Do you have a contract? Yes. I review the contract. If there's no prevailing party provision in that contract, they're not going to be able to recover a dime of their attorney's fees under most circumstances. So when they want to file suit or send a demand letter or do anything to pursue those amounts owed, every dollar they spend, they're not going to recover. And while $20,000 might be a big chunk of money to a business, you could easily spend $20,000 on legal fees if the other side's resisting payment. So having that language in your contract is incredibly valuable. So say you do the work, project's complete, and you're not getting paid. There are key dates that you must look at. First, let's discuss what is a claim of lien. A claim of lien is an encumbrance on a property. Essentially, it's a secured interest in the property that you're working on. Notice of commencement is important for lien purposes for several reasons. First, the notice of commencement identifies the property owner. Sometimes the contractor is doing work for an entity that they believe may be the property owner, when in actuality it ends up being just a leaseholder. That dramatically impacts how you proceed with the lien and whether it's even worthwhile to proceed with the lien. Notice of commencement also identifies whether there's any sureties. So if this is a bond claim, not a lien claim, it should be reflected in the notice of commencement. Another reason why the notice of commencement is important is because that's when your lien would relate back to. So if the notice of commencement was recorded in June of 2018 and you record your lien today, your lien would actually go back to June 2018. So if there are any secured interests on that property after June 2018, you would actually have priority over that lien, which would make your lien much more valuable. Notice to owner requirements are also very important. Notice to owner requirement, or notice to owner is only required if you are not in contractual privity with the property owner. So if you're the roofer and you contract directly with the property owner, you don't have to worry about a notice to owner. But if you are a subcontractor, if a GC reaches out to you and says, hey, can you perform this work, or if you are the framer and GC reaches out to you and says, hey, do this framing, you are required to provide notice to owner to all upstream parties within 45 days of your first day of work. So you could be in the middle of the project, 3 months in, you could be speaking to the owner on a daily basis. But if you did not provide that statutory notice within 45 days of your first day of work, you are out of luck. You do not have lien rights. So say you are the roofing subcontractor, you did what you're supposed to do, you serve the notice to owner within 45 days of your first day of work, and you're not getting paid. What do you do? If there's not a bond on the project, you follow the standard procedure under Chapter 713 to put a lien on the property. The lien form is pretty boilerplate. There's certain requirements, but generally speaking, you reference who you are, who you contracted with, what scope of work you did, what was the total dollar amount of the contract, how much are you owed, first and last day of work, sign that document, and you're required to serve or record that in accounting within 90 days of your last day of work. So if you are at day 45 after you're complete, and you're calling up the GC, you're calling up the property owner, and they're not paying you, I would recommend getting on the horn with your attorney because protecting your lien interests are very, very important. Not only do you have to serve that or record that document within 90 days, but you also have to serve that lien on the property owner within 15 days of it being recorded. A lot of these deadlines are very important and they're strictly construed. So a lot of times businesses try to handle notices and things like that themselves, but if they do not strictly meet these deadlines, they are going to be in trouble. Courts do not compromise due to the fact that a business owner can't afford an attorney or didn't strictly meet that deadline. As far as the liens go, oh, sorry, the question?
How do you prove the last day of your work on the job?
That's oftentimes very difficult. A lot of times I review timesheets. Oftentimes we have to provide affidavits for witnesses, things like that. Frankly, surprisingly actually, it is not often a primary disputed issue. I would say about 5% of my lien cases involve a dispute as to whether or not the last day of work was actually accurate. Oftentimes, when the last day of work is in dispute, is a dispute over what constitutes the last day of work, and that's actually very important as well. The last day of work is considered the final furnishing of a project, and what that means is essentially the last day of substantive work on the job site, so work that previously hadn't been done and it's work under that agreement. So if you were to go back, or if you complete the work and 45 days later they ask you to come back and fix a scratch or clean off the surface or do something like that, that doesn't extend your last day of work. Your last day of work was actually the last day you completed that job. So oftentimes punch work, cleaning work, service work, things like that, our clients believe that that pushed back their last day of work when in actuality that did not. And that makes it difficult for us to tell them that, hey, I know you went back to the project and did this work, but if you record this lien and the judge finds that your last day of work was actually more than 90 days before when you recorded that lien, you are potentially subject to a fraudulent lien claim by the person who's not paying you. So if you record that lien after 90 days of your last day of work and the homeowner sues you for fraudulent lien, they could recover their attorney's fees despite the fact that they are not paying you for that project. So that's why it's incredibly important to document your last day of work. Make sure you keep those time cards, paper trails. Send emails out saying, hey, we just reached completion on X date, please send us final payment. That's why it's incredibly important to keep that paper trail. Other things to look out for. So you have a lien recorded, but you say, hey, I want to work things out with the property owner. I'm going to let it sit there because it doesn't expire for 1 year from the day it's recorded. Sometimes property owners and their attorneys will record what's called a notice of contest. Notice of contest is very important because oftentimes business owners do not know what exactly that means. They still sit on that lien thinking that they have a whole year to file suit on it. The notice of contest is important because that 1 year period gets shortened down to 60 days. So if you are the roofer who just put a lien on the property and you get served with the notice to owner, you need to contact your attorney immediately because that lien that was otherwise good for 1 year is now shortened down to 60 days, and you have to decide, am I going to file suit on this lien or am I going to let it expire? After it expires, you can't go ahead and re-record the lien. So that's one thing to look out for. Also, if you get a document called a request for sworn statement of account, this might seem like a seemingly innocent request. It might be like a demand letter like you may have received from several attorneys that mean nothing, you throw it in the trash, but it can be very important. Basically, it's a request to the contractor saying, hey, sign this affidavit telling me that this is actually the amount you're owed, and also tell me if you owe money to any subcontractors or suppliers. If you do not provide them with that document, they have an argument under the Florida statutes to say even if your lien is valid, you shouldn't be entitled to attorney's fees because I'm prejudiced by you not providing that information. So little things like that is going to be incredibly important for you to pay attention to. Another thing that oftentimes is overlooked, and I'm not sure if any of you involved with especially fabricating materials for a project, but oftentimes we represent a lot of businesses that all they do is the fabrication for a project, and then at some point after they fabricate the materials, the project or the contract gets canceled, and they're stuck with these materials that they specially fabricated. They cannot use them on any other project. What do you do? Generally speaking, on a lien claim, you can only lien for work you actually did on the project, hammer and nail work on that project. If you have a $30,000 contract and you get fired halfway through, you can only lien for actually the work you did. So when I have clients who all they did is specially fabricate materials were never actually incorporated in the project, and they think they're stuck, Chapter 713 of the Florida statutes actually does have a narrow section that does allow a business that fabricates materials to record a lien strictly for the cost of the specially fabricated, or of the materials that were specially fabricated. The only burden you have to prove is, one, the cost of the active materials, and two, whether or not those materials can be used on any other projects. If you ordered a standard window for a project and you're trying to say, hey, this is specially fabricated, they have an expert that takes a stand and says, no, you could use this on any number of projects out there and still recover those costs, and that would impact your claim. But if those materials were specially made for that project, then you would be able to lien for the dollar amount of those materials. Now, bond claims as a whole is very similar to liens, except for you're not actually encumbering the property. If a bond is basically like an insurance policy saying, hey, if anybody downstream isn't getting paid, they can make a claim to this insurance carrier, and the insurance carrier will evaluate the claim and pay it out if it is a valid claim. With bond claims, there are also very similar but important requirements. Notice to owner, notice to contractor. This is a situation where the downstream contractors are required to provide notice to everybody upstream that they are working on the project and that they will seek a claim on the bond if unpaid. In this situation, typically it's the prime contractor who secured the bond. So if you're the subcontractor of the prime contractor, you actually do not need to provide the notice to owner. It's only anybody who's been hired by the subcontractor going downstream is who would have to provide the notice to owner. This, similar to the notice to owner with lien claims, has to be served within 45 days of your first day of work. Next is the notice of non-payment. Notice of non-payment is important. It's similar to, it acts similarly to the claim of lien. There's two different, or I should say, there's different kinds of bonds. There's private bonds, which are dictated by Chapter 713 of the Florida statutes. There's also public bonds, which are governed by Chapter 255 of the Florida statutes. At the federal level, there's also Miller Act bonds. which acts very similar to our state bond laws here in Florida. The notice of non-payment on private bonds, if you are a subcontractor or anyone downstream from there, you are required to serve that notice of non-payment within 90 days of your last day of work. When it comes to state or federal bonds, the Miller Act bond, for example, if you are anybody beneath the subcontractor, you have to provide the notice of non-payment within 90 days. In that situation, if you have a contract directly with the prime contractor, all you have to do is file suit within 1 year from your last day of work. So that gets into very, very technical issues. So if there is a bond on a project, I would highly recommend seeking legal counsel, even just to get their advice as to whether or not it would be beneficial to proceed on the bond plan. So the dispute process. When I have a client that comes to me and says, hey, we're not getting paid, first thing I always ask about is whether or not they met the notice to owner requirements, whether or not the last day of work was within 90 days, basically evaluate whether or not they have lien rights or bond rights. The reason that's so important, especially with liens, is that gets the property owner's attention. Regardless as to whether or not you have a contract with the property owner, when the property owner gets served with a claim of lien, they don't like it. So that automatically gets the attention of everybody upstream from who you've been working with. Another reason why it's important is that it's a secured interest. You're not going to try to collect against the big bad GC who really has no cash flow and would go out of business if you get a judgment. It's important because you now have some collateral there. You have the house or the structure there that, if necessary, you could potentially foreclose on that lien and, depending on the nature of the mortgage and so on, take possession of that property. Or have it sold and collect the proceeds from that sale. After evaluating their lien claim, I'll look at their contract. I'll look to see whether or not we comply with the notice provisions, what their dispute resolution procedure is, where the venue is, see if there's a prevailing party provision like I discussed before. And then from there, typically, we like to send a letter first. Now, litigation, oftentimes clients say, let's put the pedal to the metal, let's file suit, let's go after them, but they don't recognize that the filing fee alone in Florida, for example, in circuit court is $450 and up. So not even taking into account the cost of reading through the documents, preparing the complaint and so on, you're paying $450 just as a filing fee. So it can be very expensive. So if this is a situation where we can get it resolved without having to file suit, we will prepare just a nastygram and send it out to the person you're contracting with and say, hey, pay within the next 7 to 10 days or else we're going to record a lien, we're going to file suit, we're going to steal your kids' money, we're going to do everything to go after you. If that doesn't end up working out, that's the point where I sit down with my client and evaluate the pros and cons of filing suit. I gave you the example before where it's a $20,000 collection matter, but there's no prevailing party provision. At that point, I would tell our client, hey, we can file suit, but we're going to sue in a very cost-efficient way. We might not serve all the discovery up front. We may not dive into all these extensive phone conferences because at the end of the day, every dollar you spend on us, you're not going to be able to recover. If there is an attorney fee provision, I'll go into more detail as to what we can do to really put pressure on them. If they're a GC who thinks that they can just not pay their sub, or if they're a property owner who thinks that they're just going to lowball the party they contracted with, when they get sued and they also receive a request for production, interrogatories, and their attorney's saying, hey, they want to take your deposition, they may be more inclined to say, okay, I'll step up and pay as long as I don't have to pay for attorney's fees and go through this whole process. So that's where, especially when you have a prevailing party provision where you can recoup some of those fees that you've been spending, that's typically what you would end up doing right from the get-go. Oftentimes clients ask me whether or not it's beneficial to proceed with arbitration. There's pros and cons with arbitration. If it's beneath $25,000, oftentimes it is sent to what's called fast-track arbitration. Fast-track arbitration is a bit of a crapshoot. There's not the extensive discovery. It's essentially a good faith exchange of documents during a short period of time, and then they'll assign you to an arbitrator. In the construction industry, typically the arbitrator is associated with the construction industry American Arbitration Association. So you at least have the benefit of having a board-certified construction attorney or someone who has familiarity with construction handling the case. That's a benefit. If it ends up being a more larger scale arbitration, yeah, some costs might go down as far as discovery, but you also have to pay the arbitrator. So not only are you paying your attorney, but the parties are splitting the cost of the arbitrator that just got assigned your case, whose billable rate is probably $450 and up. So every dollar that arbitrator spends going through motions, going through filings, things like that, you're not only paying your attorney to prepare it, but you're also paying the arbitrator to go through it. So when it gets to larger scale arbitrations, I typically do not even like them. Granted, yeah, you might get the benefit of somebody who knows what they're doing, adjudicating the dispute, but it can become extremely expensive. On top of that, if you serve discovery and the other side's not responding, it's a little bit more difficult to get that court order to say, hey, mandate them to respond, or else they're going to be responsible for all of our fees. You can, even in some extreme circumstances, issue an arrest warrant, things like that. Filing suit in circuit court is the more common route. The one downside of filing suit in circuit court or county court is that it can be a long, drawn-out process. I don't know if any of you guys have been in lawsuits, but even if you want to light a fire under the case and send it directly to trial, the fastest you could get before a judge is likely 12 to 16 months. More likely than not, I would say between 24 and 36 months before that case is being adjudicated upon. Some businesses that need that money, that contract that they got stiffed on, it's not exactly easy to go that route. So that's why mediation is now mandated by essentially all Florida courts. So you file suit, you have the lien claim, you have the breach of contract claim. You also bring in an equitable claim just to be safe against the general contractor and the owner, or just the owner if that's all you contracted with. What can you do to make sure that you are presented before a neutral party and opposing counsel to get this matter resolved? Now, what I typically do is after initial discovery is sent out, so after we send a request for documents or after we send out the request for sworn statements, I'll set that case at issue. And what that means is I'm telling the judge, hey, we handled the initial pleadings, discovery is already underway, we are ready to get a trial date set. And when a judge sees that, they say, okay, but I don't want to hear this case. What I'm going to do is mandate you guys to go to mediation. And that's where oftentimes, no matter how strong or weak the claim is, that is typically where cases get settled. It's an incredibly valuable process. Granted, you are paying the mediator, you're splitting the cost similar to arbitration, but in a one-day period, oftentimes you can go from an impasse from one side being at 0, the other side being at 1 million, to actually settling out a case. And that's where it can become incredibly valuable to step up to the table, recognize the risks of going to trial, and get it settled. So I just flew through the general dispute process, contract considerations, things like that. What questions do you guys have as far as any of those topics?
Sure. Question. So let's say you get a job done with a contract, and after you didn't pay, and can I still put a lien after he left the job? Just put a lien in the house as the homeowner have nothing to do with me?
Yes, absolutely. And that's why the notice to owner is so valuable. So if the GC just disappears and you were the sub who got stiffed and did your part of the job, absolutely you could put a lien on the property.
But
What?
I'm going to say, well, so I already paid the general contractor for the whole job, and I already paid for the insulation. Excuse me, I already paid for the insulation, so I have nothing to do with you.
That's a very good question. So on that notice to owner document that I mentioned before, that a sub is required to serve within 45 days, on that notice to owner requirement, it says in giant letters, warning, make sure that any payments made to your contractor are being paid to this entity serving the notice to owner. If you do not verify that payment is made to the subcontractor, then you could be responsible for double payment. So even if they did pay the GC, if you were the sub-roofer and they paid the GC for your scope of work and the GC takes that money and disappears, they would still arguably be on the hook for paying you your amount of money as well because you served the notice to owner. That's why when oftentimes you're a sub and the GC says, hey, I'm not paying you until you sign this lien release and this waiver and lien release, that's why that document is important. Typically, the property owner mandates it, or a smart owner would mandate that to make sure that they won't be on the hook for double payment. So you absolutely do have that right. And if you were to file a suit in that circumstance, if you record a lien, the owner is up in arms because they already paid the GC, how I would approach that is I would do lien foreclosure against property owner I would do breach of contract against GC. Regardless, we will do our best to find them, see if there's any money there. And then also what's called unjust enrichment, which is basically a safety net claim against the property owner. Unjust enrichment is basically if the judge says, hey, the lien's invalid, the breach of contract, or the contract is unenforceable, it's that safety net saying, okay, if the lien's invalid and the contract's unenforceable, I still did the work. I still should be owed the reasonable value of the services I provided. So it's kind of that safety net for you to claim against the owner. So that's generally how you'd go about it. Sorry, do you have any questions?
My last question. In time, let's say I get a job done, I have certain times I would come back and knock the homeowner's door and let him know what's going on, or after like 45 days or 9 days, I don't have a right to do this anymore.
What was the question? I'm sorry.
It's time for him to go knock the homeowner's door. Let's say I did a job for the contract, he didn't pay me. I'm gonna just go over the homeowner and say, listen, I did his job. I didn't get the check. So then they say, well, it's over like 3 months, so the job is 3 months behind. I still have a right to do it, to put a lien in the house, or...
So after the 90 days, so say you and the GC have been talking for 90 days, you think the GC has good faith that they're going to pay you, 90 days passes, you're still not paid, you want to go to the property owner to ask him, or to tell him, hey, we haven't gotten paid, you need to pay us, you absolutely do have the right to do that. That unjust enrichment claim that I just discussed before, that would be the claim to bring against the property owner. The way in that circumstance, that would be your only claim to bring against the owner. And if the owner shows proof to the court and say, hey, look, I paid the GC, here's the check stubs, shows that the GC cashed them, the owner hasn't been unjustly enriched. The owner paid for that service, and your cause of action would be against the GC. And something that typically only attorneys who deal with construction recognize, or some leverage that you can recognize, is that in that scenario, you're the subcontractor, and the GC thinks that they can get away scotch-free, that they don't have to pay anybody. One key thing there is going after that defunct business who disappeared may be worthwhile, because that business has a license holder. And under Chapter 489 of the Florida statutes, that license holder has an obligation to make sure that there is no judgments entered against his business, especially for financial misconduct. So if you get a judgment against that defunct GC, who you will probably never collect a dime from, you can file a complaint to the DBPR. DBPR complaint will say, hey, we were a sub on this project, this GC, this license holder, this qualifier did not pay me, here's proof of that. The DBPR will go after them, and I'm not telling you that the DBPR will pay you that claim, or they will absolutely force that GC to make that payment, but they may go to that GC and say, hey, this is going to be a knock on your license, you're going to have to pay us a significant fine unless you can show proof to me that you've resolved this claim with this subcontractor. And oftentimes it can get to that point where you already have a judgment, you're trying to go to collections and you're having trouble collecting, and then the DBPR knocks on their door, sends a letter, and now they're like, well, crap, I know this was one business, one case, but now the DBPR is talking about my livelihood. And if this is a second or third complaint against that license holder, that could potentially be a suspension or revocation of the license. So that's where, that's an avenue to pursue to potentially get that general contractor's attention to get payment. Anybody have any other questions? Sure.
It sounds like the protection for a subcontractor is the contract. Is that a correct assumption here?
Absolutely. Well, there's two ways of looking at it. Yes, the contract, because oftentimes a lot of your rights are dictated by that contract. But that notice to owner, if you're a subcontractor, it should be regular business practice that whenever you get awarded that contract and whenever you're about to start work, that automatically is, of course, the business you send out that notice to owner.
Right.
Look up that notice of commencement, see who all the parties are upstream, and get that notice sent out. And do it certified mail, track that notice, because we've had cases where there's disputes as to whether or not that notice to owner was actually sent. Oftentimes, if you go through a third-party service, whether it's attorney office or not attorney's office, there'll be a tracking number on that document so that there are ways of verifying that. But that's important for the lien rights. For the contract rights, absolutely, oftentimes the terms of that contract are important. And even if you have a paid when paid provision, I know we talked about that before, and you're thinking, you're sitting here 45 days out and the GC is telling you they haven't been paid, sometimes the subs think, well, if I don't have a contractual right to collect, then I don't have lien rights. That's not actually the case. So you may not have a contractual right to that money based on the paid when paid provision, but you still have lien rights. So what I would recommend is, hey, while they're solving their issue out, the owner and the GC, get that lien recorded. And you don't have to necessarily take an adversarial position with the owner. There could still be informal discussions. You could be working with the owner and say, hey, what do we need to do to get this done? You can tell the owner, hey, I recorded this lien, but I did it to protect my rights. I'm still willing to compromise. I'm still willing to work with you. So it doesn't have to be that shot to the heart to the owner to say, oh, crap, I got a lien. Now I got to be aggressive and hire this attorney down the street. So that's one thing to keep in mind as well.
So to that effect, it makes sense to manage internal contracts. So if you have your own standard contract for most smaller deals, I would say, but for a subcontractor that's going to do a lot of work for builders and larger contractors, typically they're looking at the builder or contractor's contract. Do you have any guidance on standard processes to implement for, section? You mentioned several sections, and so I'm looking maybe for guidance on key sections to pay attention to and to figure out what to try to negotiate and ask for, compromise on.
It's a good question. Yeah, I mean, I do a lot of contract reviews. I'm just thinking how I would necessarily go through it. Well, the venue provision is often huge. Taking conditions as is. That's when I do a lot of site work contracts. And there's oftentimes, hey, by signing this agreement, I am certifying that I inspected the grounds, and any latent defect that's discovered after the fact, I'm responsible for it. I carefully word, I always modify that language because I don't want there to be some significant issue, a sinkhole, and all of a sudden our guy who's doing the site work is responsible for this damage. Granted, I believe a judge would find that to be unenforceable, but there's not necessarily that clear line there. I don't want to even have to go through the process of making that argument. So that would be one thing I'd look at. Indemnification is huge. Indemnification basically means GC is being sued by the owner for something within his scope of work in the project. If it's arguably related to subcontractor scope of work, your contract will likely say subcontractor has an obligation to hire the attorney for the GC and cover all defense costs and pay out the claim to the extent that it's related to their scope of work. That's one thing that we typically try to wordsmith a little bit. We try to make sure that it's limited. Any claims related to any grossly negligent or willful conduct of either the owner, the GC, or any third party, I typically add that language in to say in those situations, subcontractor is not responsible to indemnify you. It's only, their indemnification obligations are only valid to the extent that the claim is related to their scope of work. That's a provision that I typically look at. Notice provisions. Sometimes, there's termination for convenience language where they can terminate you for any reason. There's default provisions where, hey, if you're defaulted onto the project, you have X amount of time to either take care of it, or we can supplement your labor and hire someone else and take it out of your contract. So that's actually one thing that I see a lot. A lot of the times when we see that provision, it will say, when you get a notice of default, you have 24 hours to go ahead and remedy this whole problem. And that is damn near impossible to do in most circumstances. So what we typically do is either limit the recourse the GC would have in supplementing labor or taking their own measures to help out the process, or extend that time period. Instead of 24 hours, we would say at least 72 hours, if not 5 days, to which that subcontractor has an opportunity to bring in their own staff, take care of whatever issues they're being defaulted for, and get it resolved that way. So there's a lot of little provisions I look at. Those are some of the key ones that I typically push back on, that the GCs actually do compromise on. A lot of times my clients who have subcontracts, these 30-page subcontracts, they think that they have absolutely no leverage, and oftentimes there's some provisions that they don't. But there are times where the general contractor will say, all right, if this gets it done, if this gets you out on that job site, let's just get it signed and go on. They are contracting with you because either they trust your work or you're the lowest bidder. So if you're pushing back on a provision that in all likelihood will never be implicated, then that GC would actually be inclined to just sign it, let it go on. So, yeah. Yes,
There may be a GC who approves a change order, and they turn around and don't pay because they said, well, we haven't been paid by the owner, they haven't approved it yet. And that's part of your contract. Can you go after them on a lien?
What's part of your contract that the owner?
Yeah, that it has to be approved by the owner.
So change orders are, so there's two ways of looking at this. So change orders are often important when it comes to liens, because oftentimes my clients will say, hey, let's lien it up. I did the notice to owner. It's been less than 90 days put lien on the property. I'm owed $300,000. And they'll send me the contract, and I'll say, well, your contract says it's only $250,000. Where does this other $50,000 come from? Say, oh, well, you know, the owner told me to do some work, and I went ahead and did it, and that's $50,000 worth of work, so let's lien for it. I'll look at the contract, and I'll say, well, it must be written by, or a written document signed by both sides. I'll say, okay, well, can you send me over that document where it's written and signed by both sides? And they don't have it. They say, well, no, they told me on the job site to do this work, and it was $50,000. They told me that they were fine with that. What I would typically do in that circumstance is I would lien only for the contract price. In that first count, that lien foreclosure, I would lien for $250, and in the breach of contract, I would seek that full $300, because the lien statutes and courts strictly construe those statutes. And if you have an overstated lien, or if the property owner says that they willfully overstated this lien, they included $50,000 that they knew they didn't have a contractual right to, that's where that attorney fee provision could flip to the other side, and you could potentially be on the hook for their fees, even though you were owed $250,000. Now, to your question as to whether or not it's collectible in a pay when paid, absolutely. That agreement, so your subcontract requires that written change order. You have a written change order. You have a contractual right to that amount of money. Now, if there's a pay when paid, they would have contractual defenses to that amount of money. But if there's no dispute about that change order, that it's a valid change order under that contract, you are well within your rights to include that in your lien claim. So in that example that we just went through, if that change order was actually a valid change order under that contract and in accordance with the provisions in that contract, that increases your total contract amount. So the way I would word it in the claim of lien is I would say the parties entered into a contract for this property for a total of $300,000. In parentheses, I would put including approved change orders, so that in the event that there's a dispute as to why we increased that total contract amount up to $300 when there's a document that says $250, I would say, well, we made it clear in the claim of lien that includes an approved change order, and here Exhibit A is the approved change order signed by both parties.
But not often do you get that until after the work is done.
How often do you get what?
The change order signed. So sometimes you're given a change order, and a change order is discussed, and you get told in an email to proceed, but you still have to bill, and you don't get that signed change order until probably 30 days after you've done the work.
I see that all the time.
Yeah.
And it's awful because the subcontractor is engaging in good faith. They have an obligation to do work when directed. They have an obligation to keep up with the project schedule. And sometimes there are some stingy GCs out there who think they're smarter than everybody and think that they can get some free work by not providing that change order timely. Now, if they end up providing that change order after the fact, it's still enforceable. The problem is, are they going to issue that change order, issue that signed change order for the price that you discussed? That's where oftentimes there's disputes, at which point, as a sub, you may want to treat it as a change directive, which is very similar to a change order, but it's essentially an immediate improvement or immediate change to the scope of work that needs to be completed, at which point oftentimes the contract would allow the entity doing the work, the subcontractor, to keep track of time and material, and perhaps there may be some profit and overhead built into that change directive as well, but oftentimes that can become a very big problem. That's why, if possible, make sure that there is a signed written agreement. If you have to send an email citing that provision in the contract to say, hey, look, GC, we want to help you out, we want to do this, we want to get out there today, but we don't have that signed change order. See Section 5.8 of the contract that requires a written change order signed by both sides. Once you provide me with that change order, I will sign it immediately and I'll have a crew out there by the end of the day. That's why I typically push one. I know in practicality purposes, That's not always easy to do that, but if your contract has strict change order provisions, make sure that you follow those. Sure.
A question about the lien waiver, when you sign the lien waiver.
Mm-hmm.
They always ask me to sign it before they give me my check.
Mm-hmm.
But, you know, to me, I'm like, well, what if I sign this, they never send me my check, or check bounces, or this or that?
Yeah, so me and my colleagues still talk about the general process in the construction industry as far as the lien waivers, what the difference between conditional and unconditional, things like that. The normal course of practice should be that you provide a conditional lien release reflecting work performed either through this date or a certain amount of money, and you submit it with your pay application to get paid. I know oftentimes it is silent on as to whether it's conditional or unconditional, but if you, generally speaking, while they may have an argument that, hey, you gave me this lien release and therefore you've waived your right to this amount of money regardless as to whether I paid you, that's a tough argument to present before a judge. I've had that argument brought to me informally from opposing counsels, but it's never gotten to the point where they're legitimately arguing before a judge that I know my client didn't pay them, but they gave me this lien release for that amount of money, and therefore they shouldn't be allowed a lien. It's kind of a gray area, but the way I view it is that those lien releases that you provide prior to payment are de facto treated as a conditional lien release. So if you are not paid, if you came to me and said, hey, I did provide this lien release, but it was only to get payment. Under the contract, I'm required to do this to get payment. I would not say let's exclude that from the claim of lien. I would include that amount in any kind of claim of lien. Absolutely. Any other questions on contracts or collections or liens or anything? Sure.
Is the notice to owner pretty standard for every state, or is that kind of different to individual states?
Generally speaking, it's pretty standard, but the one benefit with notice to owners is that they're governed by statute in I believe every state. So it's as simple as Michigan notice to owner requirements, and it should point you directly to the Michigan law or like the Florida statute with exactly what you need. And another benefit, we typically, obviously for our own reason, we like to have the business, but the notice to owner requirements are construed just as strictly as claim of liens. If you do a notice to owner and you don't serve it on every party upstream, or you send it to the wrong party or the wrong address or anything like that, that could jeopardize your lien rights. We see that a lot with third-party non-lawyer services when we get these notice to owners that look like they're in great form and everything like that, but there is some mistake on there that prevents them from filing a lien. That's very important. That's why we typically say, hey, it's more expensive to come to a law firm, whether it's us or another construction law firm. It's more expensive to do that for a standard boilerplate notice to owner, but that work that goes into notice to owner will actually reduce your fees when it comes to preparing the claim of lien, because that attorney already did the job of looking up every party upstream, fact-checking the property, looking through the public records to see what encumbrances there are, making sure the property description is correct. So to answer your question, generally they're the same, but they are governed by law. So closely review the law. If you check off every requirement in that statute, then you should be good to go.
Sure. The notice to owner obviously has to have the price in which you're contracted for, right?
Not necessarily. That also varies state to state. So that would not be my primary concern when I serve a notice to owner. My primary concern is who you contracted with and what your scope of work is. That would, granted, I've never had that become an issue as far as they don't believe us as being a subcontractor, but that does provide notice to the owner as to who you are and what you're doing. So if they get a notice to owner from Joe's air conditioning, they'll look for HVAC work to see who to Joe is, and if there's any dispute there, then
It wouldn't be, say, big for me to threaten a notice to owner, which would disclose the contracted price of, let's say, the 60-day mark. Contractor, would that be?
what's the
In other
question?
words, at the 60-day mark, when I'm already sitting here saying, all right, we negotiated for 30 days here, this is twice as long, I don't want to go down to the wire, kind of threaten my customer that I will send a notice to the owner.
Threaten a lien for the customer you already sent a notice to owner to?
Threatening the builder that I'll do a notice to owner.
Well, for notice to owner, 45 days is the key day. So that's what I would focus on.
At the 60-day, can I tell the builder that I will? do
Can you
that?
threaten the builder that you're going to record a notice to owner, or serve, I should say, notice to owner? You that I mean, if the general contractor's smart, he would know that you could serve it, but it's not going to mean anything because it's invalid. Two, granted, I've never seen this happen before, but maybe a creative attorney, if that was made to threaten, hey, pay me or else kind of a situation, there's a Florida Consumer Collection Practices Act that I do not necessarily see that ever prevailing, but they may threaten you and say, you are making threats that you know under the law you have no right to. So they may try to flip the script on you and go after you that way. I would probably do that even though I would never pursue a claim on it. I would do that just to get whoever's barking at me to back down if I were doing it on the other side.